morning, students. Good morning, children. This is Srikanth. Yes, signing in for contracts 1. Slowly, we are completing the consideration. So, you know that consideration means something in return. It may be in cash or in kind. So, we have read that consideration may be past, present, or future. The important point is in a contract there should be some consideration. Both the parties should have some consideration. That consideration should be lawful consideration. ஒரு கான்ட்ராக்ட்ல ரெண்டு பேர் இருந்தப்போ ரெண்டு பேருக்கும் கன்சிடரேஷன் இருக்கணும். ఒక్కరికి இல்லைன்னா కూడా అది కాంట్రాక్ట్ கிடையாது. సో ఒక కాంట్రాక్ట్లో ఇద్దరికి కూడా కన్సిడరేషన్ అనేది ఉండాలి. ఒకరికి లేకపోయినా కూడా అది unenforceable. So consideration is very important ingredient for the formation of a contract. This consideration should be lawful. It need not be in cash. It may be in kind or otherwise. So here we are going to see one concept, past consideration. In fact, past consideration is no consideration. Let us analyze what is this past consideration. So, past consideration means where the promisor means offerer, had received the consideration before the date of promise. Such a consideration is called past consideration, where the promisor had received the consideration even before the date of the offer or promise. Such a consideration is called past consideration. So let us see one example. Promise for past services rendered. What happened here? A was going to his office in a scooter. Suddenly, the scooter stopped due to some technical defect in the engine. Then A requested B, who was going there, to repair the vehicle, and B repaired the scooter. After repairing the scooter, A promised to B rupees 100 in consideration of his past service. In consideration of his past service, it is known as where the promisor had received the consideration before the date of the promise, such a consideration is called past consideration. Here, A promised B to pay rupees 100 in consideration of his past service. So, you know that in a contract there should be consideration. A contract without consideration is void. Remember. So in a contract, two persons will be there. Assume that A and B both should get consideration. It is something in written, and this consideration should be lawful. So without consideration, contract is void. But however, section 25 speaks about one thing, that is, a contract without consideration is valid in certain circumstances. The general rule is a contract without consideration is void. But however, in certain situations, a contract even without consideration, it is valid. So, the general rule, a contract without consideration is void. It is said that a contract without consideration is void. That means for the validity or enforceability of a contract, consideration is essential. However, section 25 of the Indian Contract Act provides for certain exceptions to this general rule. What is the general rule? A contract without consideration is void. So section 25 speaks about certain exceptions are there. According to section 25, a contract is valid even without consideration in the following cases. One is love and affection. Number two, compensation for voluntary services. And number three is time borrowed debt. Time borrowed debt. In these three situations, even though there is a contract between the parties and even though there is no consideration, till contract is valid. What are those three things? Three exceptions. One is love and affection. Number two, compensation for voluntary services. Number three, time borrowed debt. So, first point is love and affection. So, according to section 25 class 1, an agreement between two relations out of love and affection is valid even without consideration. So, here what happens? Assume that A is there. A is having a daughter by name B. A is transferring the property to B without any money. Here A is not getting anything, daughter B is getting property. Then what happens to A's consideration? A does not have any consideration. At the most, he can have love and affection of his daughter. It is his consideration. So, this love and affection itself is a consideration of A. Again, this agreement should be expressed in writing and it should be registered under the law for the time being in force, and this should be made on account of natural love and affection between the parties standing in a near relation to each other. So that means whenever two persons are entering into a contract out of love and affection, they have to enter into a contract with only near relation people only. You cannot enter into a contract with a distant relative. So the contract to be valid as per love and affection, certain conditions are to be satisfied. The parties must stand in some relation. So A is there, B is there. A and B is a father and daughter. That means they are having some relationship. A cannot transfer his property to his friend for love and affection. Why? They are not standing in near relationship. Second point is the agreement is made out of natural love and affection. So this agreement should arise out of natural love and affection. Third one is the promise must be in writing. You have to write it that out of natural love and affection I am giving this property to my daughter, and it must be registered under the law in force. These are the 4 points to be satisfied for love and affection. One is parties must stand in some relationship. The agreement is made out of natural love and affection. The promise must be in writing and it must be registered under the law in force. So this is first point. Second point is compensation for voluntary services. So compensation for voluntary services means without any consideration. So according to section 25 clause 2, an agreement without consideration is void, but still compensation for voluntary services is valid. A promise to pay for past services is legally binding. Past services, for example, one person was there, He is going on the road. Suddenly, he found a bag. He kept the bag with himself. Subsequently, another person came and tell to this person that this bag belongs to me. Then this person will pay to that person that bag. So the person who is getting that bag will pay some rupees 100. That means it's a compensation for voluntary services. You understand? Here, A is not demanding any money from B. B is voluntarily offering some money to A, that because A has given the bag. So A has given the bag. It is the compensation for voluntary services. You are doing the service without expectation of any consideration. Subsequently, if that other person pays you, it is legally enforceable. Third one is promise to pay time borrowed debt. Time borrowed debt means we are having one act, Limitation Act 1963. For example, if anybody takes a promissory note, the time is only 3 years. Within these 3 years, you have to pay the money. After these 3 years, if you go to the court, court will tell that your time has been barred and your suit is not actionable. Section 3 Limitation Act 1963. So a debt barred by limitation is declared bad if the debtor or his authorized agent makes a promise to repay it. It is a contract without consideration. It is valid and enforceable. So what happens? A is there, B is there. A has taken money from B. B has given a promissory note to A. But what happens? 3 years has lapsed. Now A cannot go to the court and file a suit against B for the amount. But B tells to A, don't worry, even though 3 years has been completed, I will pay back you the money. So it is a promise to pay time borrowed debt. In this, there is no consideration. No consideration. Normally, what is the general rule? No consideration, no contract. But here, even though there is no consideration, it is a valid contract and it is enforceable. Now tell me, without consideration, no contract. However, under section 25, even though a contract is without consideration, it is valid. What are those 3 points? One is love and affection. Number two, compensation for voluntary services. And number three is time borrowed debt. So these are the 3 points enshrined under section 25. The general rule is a stranger to a contract cannot sue. It is also known as privity of contract. For example, A is there, B is there. Whenever there is a breach of contract between A and B, either A has to approach the court or B has to approach the court. So that means third person cannot file a case on behalf of A or B because third person is a stranger to the contract. It is also known as privity of contract. But a stranger to a contract cannot sue, but a stranger to a consideration can sue. The general rule is that only parties to a contract alone can sue and be sued on that contract. Any person other than the parties to the contract is called as stranger to the contract. Why? This contract neither confers any rights nor imposes any duties or obligations on such person. Hence, a stranger to a contract cannot sue and be sued. This rule is known as doctrine of privity of contract. That means in a contract, if any party has to go and file a suit, there must subsist some relationship between the parties to the suit. For example, A promises to pay rupees 1000 to B. If he delivers goods to C, in this example, C is a stranger to the contract. If B fails to deliver the goods to C, C being a stranger to the contract, he cannot sue B. That is privity of contract. Only parties alone are entitled to file a case against breach. But however, this stranger to a contract can sue under five circumstances. One is beneficiary of a trust, second one marriage settlement, third acknowledgement or estoppel or part payment, fourth assignment of a contract, fifth contract through an agent. First is beneficiary of a trust. Trust means it is a trust created by one person for the benefit of so many persons. So here what happens is three parties will be there. Trust is created for the benefit of the beneficiary, and subsequently if the trustee misuses the property, any person to whom it was created can file a case against the trustee. Here the beneficiary can enforce the provisions of the trust even though he is a stranger to the contract. So second one is marriage settlement. Even a stranger to a contract can sue in respect of marriage settlement. Here there is a one case law. Here one happens is one person enters into an agreement with a father of a girl to marry that girl. Subsequently, he refused to marry. Here agreement was between the person and the father, but the girl filed a suit against the person for not to marry him. In this case, boy entered into a contract with the girl's father to marry the girl. Later, boy did not marry the girl. The boy and the girl's father are parties to the contract, and the girl is a stranger to the contract. However, this girl can file a case against the boy. This is another exception that has been enshrined under privity of contract. Third one is acknowledgement or estoppel or part payment. Estoppel means to stop. So here acknowledgement means acceptance of a receipt or admitting a liability. So where a person by his declaration makes another to believe a thing, subsequently he cannot deny the truth. So in this case also a stranger to a contract can file a case. Fourth one is assignment of a contract. So if the benefits under the contract are assigned to a third party, assignee can sue. Assignment means transfer. For example, A is there, B is there. A has to get money from B. Then A has to give money to C. A will transfer this B's obligation to C. That means he is assigning his contract to C. In these cases, even though C is a stranger to the contract, he can file a case against B. An existing contract can be replaced with a new contract by changing either of the parties' terms and conditions remaining the same. Fourth one is contract through an agent. So when a person appoints another to act on his behalf with a third party, it is called agency. I already told that in a law of agency, two parties will be there, principal and the agent. Who are those two parties? Principal and the agent. When the agent enters into a contract on behalf of the principal can enforce the contract. Here principal is stranger to the contract Agent and other party are parties to the contract. So these are the considerations, exceptions to this rule. That means stranger to a contract cannot sue. However, in these following circumstances, a stranger to consideration can sue. One is beneficiary of a trust, marriage settlement, acknowledgement or estoppel or part payment, assignment of a contract, contract through an agent.